All right, everybody, welcome. Let's get right to it. This is a hybrid event. I'm Dan Canstrom. I'm the professor in this class. They all know that. And also co-director of the Center for Human Rights and International Justice here at Boston College. And we decided to maximize the availability of Professor Sirleaf here, who has generously agreed to teach this class, but also do it in the guise of a public presentation, because we thought, I mean, she's an extremely interesting speaker, and also the topic is extremely compelling to the community at large, and specifically to this class, which I'll just say has been exploring aspects of human rights discourses, humanitarian law discourses, refugee law discourses, ranging from torture to deportation to all sorts of other things. So the indictment of Vladimir Putin last week with Luis Moreno Ocampo, and trying to think about, is there any coherency to this? How does it hang together? If it does, what are the best ways of thinking about it? And because I'm a human rights lawyer, we've been doing this in this class and through the center, of course, in a relatively, and I use this advisedly because we do it on purpose, a relatively naive and relatively optimistic way about engaging with human rights issues, because we feel strongly about the compelling nature of those issues. But I think it's very important to have a critical perspective on the history, and as our title suggests, the hierarchies and the history of the very human rights discourses that we're using. And this is not at all meant to disempower people. It's meant to empower you with more sophisticated, more grounded, more capacious understandings of these topics. I hope that's a fair way to introduce what you're about to say. It's my best attempt. So the questions we're going to engage with today: does the genealogy of human rights matter? Why is the history important and potentially controversial? Who are centered by different histories? Whom do they leave out? And so forth. And so leading us to that discussion today, although I will remind Professor Sirleaf that we do have two particular students in this room who have been tasked with asking specific questions, who have done a deep dive in the reading. So at some point in the presentation, if you could just unexpectedly call on them, that would be terrific. I appreciate that. A brief introduction. Matiangai Sirleaf is the Patz Professor of Law at the University of Maryland School of Law. Professor Sirleaf writes and teaches in the areas of global public health law, public international law, international human rights law, international criminal law, post-conflict and transitional justice, and criminal law. Her scholarly agenda is to make visible the extant hierarchies in international law and to remedy the inequities reflected in it, seeking to elucidate how seemingly neutral laws further global inequities. Her current research agenda sits at the crossroads between international human rights law and global public health law, where she's analyzing disproportionate distributions of highly infectious diseases and the role of international law in facilitating this result. She has a very long and distinguished resume, and actually, since we're running late already, if it's okay with you, Professor, I'm going to shorten that and just say that you previously served, you won many prestigious grants and awards, fellowships, and other honors, is an executive editor of Just Security and a member of the board of editors for the American Journal of International Law. Previously served as an associate professor of law at the University of Pittsburgh, as an assistant professor in Baltimore, and as a Sharswood Fellow at the University of Pennsylvania. She's a graduate of Yale Law School, the University of Ghana Legon Center for International Affairs, and the NYU College of Arts and Sciences. I thank you so much for your patience. I apologize again for the tech glitches. We're going to have a moment of applause to thank you, and then I'm just going to turn it over to you, but I'll be sitting here. If you need me, just call her and I'll jump back in. Thank you so much.
Well, thank you guys, and no apologies necessary. I'm really grateful to be joining you all this afternoon, and now I'm hoping someone can tell me whether they can see, I think you can see my screen, so that's good. Thank you for the generous introduction. It's really a pleasure to be here with you all to talk about a topic that's really near and dear to my heart, and is, I think all of us are interested in the topic of human rights and thinking about the role that human rights plays. And I think sometimes our sort of fervor for human rights can lead us to not really ask sort of deeper questions about human rights, about its utility. And today I want to focus on sort of just the history of human rights, where human rights situates itself, at least what the conventional account is, and try to sort of trouble that conventional account a little bit, and then see what that troubling does, for some takeaways. So first, I want to just begin by thinking about, where do human rights come from? When did human rights begin? And of course, any sort of project that tries to sort of locate a starting point or a specific beginning, it's going to be something that's controversial. It's going to be something that's contested. And that is, human rights is not unique in that space, right? So many different accounts have been put forward about where human rights has originated. And so I'll talk a little bit about that with you. I think the account of human rights that you're likely most familiar with is one rooted in the Enlightenment, and one that situates sort of the social and political change taking place during the Enlightenment, and ideas generated by philosophers like Hobbes, and writers like Locke on, for Hobbes, thinking about the idea of the social contract, and that, the governed have to consent to be governed, and thinking about Locke's theory of natural rights, and the like. And so I'm not going to spend too much time on that, because that, I think, is the space where we're most familiar. But what I wanted to talk about in this sort of hierarchy of histories of human rights is how, through sort of omission, there are ways in which alternative histories and alternative renderings of the origin of human rights is neglected. And so one could easily write a different story and write a different narrative about an account for human rights that located at least one major starting place of human rights in the Haitian Revolution, the first successful slave revolt. But Haiti and the Haitian Revolution are certainly not part of the historiography of human rights, at least the conventional historiography of human rights. Instead, the focus tends to be on the American and French revolutions, of course, the American Declaration of Independence, which we're familiar with given our situs, and the French Declaration of Human Rights. And that is irrespective of the fact that the rights that were in question at the time of those declarations were mostly related to the rights of men, the rights of propertied men, and the rights of white men. And so women didn't feature in that, and certainly people of color, Black people, didn't feature in that at all. And if you didn't have enough money to own property, your rights also were not regarded. And so I think there is a invisibilizing aspect of the history of human rights that gets compounded by sort of centering the role of certain historical moments, certain revolutions over others, even when those revolutions in themselves were not actually that revolutionary when you compare it to the Haitian Revolution. The other thing that I think is conspicuously missing from sort of a discussion of history of human rights, and a declaration that I've taken so many different international human rights class, and it's only through my own teaching on human rights that my own scholarship that I came across this declaration. And I wondered, how could it be that I've taken, so many different human rights classes at, prestigious institutions, and have worked in the field of human rights for several years prior to entering the academy. And there is this aphasia or forgetting of this 1920 Declaration of the Rights of the Negro Peoples of the World, and what the significance of this document is. And so you have before you a a document that predates the UN Universal Declaration of Human Rights. And it is notable for a number of things. It links broad categories of rights way before the UDHR does. So thinking about, and I'm sure you all in the class have discussed the sort of false dichotomy between civil and political rights and economic and social and cultural rights. And certainly, as conceived, this declaration didn't do that sort of false binary between the two. And I think it's important to think about how what we remember in history and what we forget in history also sort of defines the field. It defines the field of human rights. It defines sort of our understanding of the relevance of human rights. It defines our ability to sort of conceptualize solutions. And it also sort of obscures the ways in which massive sort of historical work is needed to address this invisibilizing, because I think that the record of human rights is actually far richer. And so what is this project? What is the relationship of this project to human rights? And how can we understand the history of this particular declaration as it relates to larger questions, which we still grapple with today? Questions of race, questions of internationalism, decolonization, questions of imperialism, questions of democracy. And all of these are still very much live issues in our world today. And one of the things that I think is of note in this particular declaration is during the speech where Garvey is talking to the crowd, he says, we are here because we are tired of being a suffering people. We are here because we desire our liberty. We believe that all those human rights that are common to the rest of mankind should also be enjoyed by us. And so again, the timing of these events taking place in the 1920 Declaration is particularly important. As I already mentioned, the false dichotomy between civil and political rights, economic and social and cultural rights is not extant in this document. There is great concern for a number of things, and you would think that it would have formed a template for much of what comes later in the human rights canon. Later covenants, for example, the International Covenant for Economic, Social, and Cultural Rights, International Covenant for Civil and Political Rights. And so the story of the 1920 Declaration, I think, can help us to think about the role of human rights, both in substance and in agency, and what this disappearing of this declaration from, I don't want to say popular knowledge, but certainly even scholarly knowledge about human rights is something I think is revelatory. So the Declaration contains a preamble. It has 54 articles. The preamble calls out racial discrimination. It calls out lynchings, racial violence against women. It calls out colonialism, and addresses a range of social and economic rights through a focus on discrimination in health, education, employment, and wages. And one of the things that is markedly absent from, if you contrast this declaration to, say, the UDHR, is the relative silence on questions of colonialism and questions of racialized forms of subordination. And so there is a way in which the lived reality in which much of the world was under when the UNDHR was being articulated is not really adequately reflected. And the drafters of the 1920 Declaration don't sort of dance around live questions of racial capitalism and others. And so one of the things that stands out when you look at the Declaration is Article 17 talks about particularly the US government, whereas lynching by burning, hanging, or any other means of human beings is a barbarous practice and a shame and disgrace to civilization. We declare any country that does these atrocities is outside the pale of civilization, right? And so that is, I think, a fascinating provision and passage for a number of different reasons. One, because of the way in which civilization is used as a sword that sort of is coming back. And I say that to say, international law as traditionally conceived only concerned itself with quote unquote civilized nations, and those who were not civilized nations. International law didn't have much to say about what happened in those territories and what was done in the name of civilization. And so what is really fascinating here is the upturning of the usage of civilization which was used as a sword and against many peoples, being used is questioning the practices of who's actually civilized and who gets to call who's civilized based on the tactics of sort of racial terror and subordination that were happening at the time and actually still continue in many ways. So the Declaration also talks about voting rights, the right to elect your own representatives, and having even-handed justice before all courts of the law. It calls for freedom of the press, freedom of religious worship, and the like, things that we are familiar with, free speech. And what's interesting is the focus on sort of a substantive equality that is, not only limited to thinking about formal equality and having access to voting and the like, but thinking about what a fulsome equality might look like. And there are 4 articles that relate to substantive equality. So a right to education, non-discrimination and access. And so if we look at, even if you think about the US Constitution, certainly there isn't, at the federal level, there isn't a right to education that is reflected, although it might be in some state constitutions. So the right to education is there. There is a demand for unlimited and unprejudiced education for ourselves. And so that, I think, seems particularly timely given where we sit today and all of the contestation and backlash around sort of an understanding of history that positions race and racism as sort of fundamental to thinking about the founding of the United States, and thinking about how systemic and institutional racism have been formative in throughout history and sort of the vestiges and legacies of that continue to be so. There's also articles focused on the right to work and that the right to boycott. And again, all of this continues to be timely as we're thinking about, what's happening in France today. And so what I find riveting about this particular declaration, in addition to the fact that it has, I think, been obscured, is the ways in which it continues to speak to concerns today, and the ways in which equality is understood in a very sort of expansive way. And so 100+ years later, I think it's important to ask ourselves, what's the legacy of this forgotten declaration? What does the forgetting of it tell us about the field of human rights? And how do we think of this essentially a civil society project to sort of articulate what human rights is, and how do we position that civil society project to define human rights from status and interpretations of human rights? And what are the, disjunctures and connections between more status, meaning more state-driven processes of articulating rights, and more civil society declarations? Particularly, I think it's important to think about this declaration as it relates to other civil society projects. For example, the African National Congress's 1923 African Bill of Rights, Václav Havel's Czechoslovakian Charter 77, which was written, and how those civil society documents and projects have been influential. And so I think there are a number of remarkable lessons to learn from unearthing this history and resurfacing and excavating it. And I think it's also important to think about how the current conversation, or maybe not as current, but the current conversation in human rights sort of historiography, to the extent that there is the burgeoning area, has still not focused on this aspect, right? There has been a lot of scholarship and debate around sort of locating the field of human rights as a precursor to human rights, rather, in the abolition of slavery. And I think Jenny Martinez is probably one of the main proponents of this. And so the argument here is that if we're trying to figure out where human rights come from, then we need to look at precursors to human rights, like the move by a number of European powers to abolish the slave trade. The Congress of Vienna, for example, in 1815, articulated that the practice of slavery was repugnant to the principles of humanity and universal morality. The Berlin Conference also noted that trading in slaves is forbidden. Of course, the Berlin Conference concomitantly, was also dividing the African continent to further imperial and colonial ends. And so how do we understand the move to abolish slavery? And can we decouple the move to abolish slavery from the furthering of an imperial project? And in the effort to try to locate human rights in sort of the anti-slavery movement, there's a way in which what gets privileged are things that sort of look law-like, and look like things that we recognize as international human rights mechanisms today. And so, so that means that individual resistance, slave revolts, rebellions, escapes, other things like collective actions that challenge the institution of slavery from people who were enslaved gets backgrounded. And instead, what gets foregrounded in this account is one that focuses on, sort of cases, the Somerset case, for example, in the UK in 1771, and different laws. So the British passed 1807 Act abolishing the slave trade, and then created a number of bilateral treaties with key trading states to try to ban the practice. This was part of British foreign policy. The enforcement provisions in the treaties included the British sort of inspecting ships and the creation of specialized tribunals. And so, again, those tribunals, those commissions look like things that we would maybe recognize today as a human rights mechanism. At the time, those commissions consisted of a commissioner and an arbitrator from each side. The British were able to decide, in fact, the British were able to decide most of the cases on their own because the other party's judge or arbitrator was either ill or absent or what have you. There was also a big civil society movement for anti-slavery. The Anti-Slavery International is the first NGO that's established in 1839. And the movement for abolition goes through a number of international mechanisms. The League of Nations took up international about abolition of the slave trade and slavery. There's a treaty, right? International Convention on the Abolition of Slavery and the Slave Trade of 1926. The aim of the treaty was the complete suppression of slavery in all its forms. And we don't see sort of the absolute prohibition on slavery and servitude that gets reflected in post-World War II human rights documents until, again, post-World War II. But there is a way in which Martinez argues that the genealogy of human rights law can be traced to the sort of 19th century movement in Great Britain to abolish it. And so that account has been challenged, and in particular around the idea that sort of rights and rights discourse were relied on in any sort of systemic way with respect to the abolition of slavery, and that the discourse that was taking place at the time was not unlinked to imperialism. And so it's hard to sort of like supplant our own sort of understandings back in time. And there is, she's criticized by Alston for overstating the centrality of international law, of international courts, of cases with respect to what happens in the different commissions and the challenges that are brought before them, and criticizing the role of other explanatory factors, as I've already mentioned, namely the role of resistance, of revolutions, of uprising, and the economic dimensions of abolition, which were in Great Britain's interest. And so trying to disconnect abolition from imperialism is a really hard thing to do, because those projects were not disentangled, they were intertwined. And this, the commissions, being able to seize ships and all of that other, all of those other measures that Great Britain was engaged in coincided with its ability to constrain the powers of others and enforce its own legal authority, and enforce its own interpretations of international law. And so locating, trying to sort of situate a precursor to human rights in sort of the anti-slavery moment seems not sort of satisfactory for a number of reasons that we just talked about and more. In addition, I'm sure you're familiar with in the class, a number of other cites that human rights is often referenced back, sort of its origin. So a common one is, diplomatic protection, right? So states enforcing their own rights vis-a-vis another state, this idea that there need to be some minimal standards for the treatment of aliens emerged, not because that person is a person or a human being, but because they're a national of another state and they're the representation of that state. But in the absence of state support for that individual, that person, the diplomat, didn't have protection on their own. So this wasn't sort of a full, you have rights because you're human, but it's one of the places that's often referenced as sort of a break in international practice, which is largely statist in its orientation and didn't really regard individuals as subjects of international law. International humanitarian law, of course, set forth different standards that were supposed to limit what could happen during conflict and lay down rules on what are the admissible means and methods for warfare. And that body of law, of course, is developed based on a shared humanitarian concerns with the plights of individuals ravaged by war, prisoners of war, and the like. So that's a concern for humans sort of in a particular condition, humans experiencing violence. And of course that the category of persons sort of keeps expanding throughout the development of international humanitarian law. Another place that's often pointed to is the protection of the population of people living underneath mandated territories. So underneath the League of Nations, the administration of former colonies defeated powers that the Allies had to administer their mandate in accordance with the best interest of the population. Of course, underneath the UN, there was also the Trusteeship Council. But this wasn't this was in sort of recognition of people subordinated in those territories as having sort of rights in and of themselves. This was still informed by imperialism, and there was a national minority regime which was developed underneath international law following World War I for the sake of preventing more conflicts. The idea was that, well, we need to really protect minorities. Between 1921 and 1923, there were a number of treaties with different obligations that a couple of states entered into. And the treaty stipulated that as part of constitutional arrangements, states would provide basic guarantees, protecting life, liberty, equality, and the like. And the League of Nations was mandated to make arrangements to supervise at the international level. So this minority regime is another space that is pointed to. And then, of course, the International Labor Organization is another situs point. The idea that workers deserve protection internationally. Again, the status of worker is the basis for protection. And that's not, protection just whether you work or not necessarily, meaning that's not based on you having rights because you're a human being. That's having rights as it relates to sort of the market and your engagement with the market place. And so all of these sort of precursor moments you might be more familiar with prior to World War II. Post-World War II, I'm certain that you have spent time thinking about the role of the Holocaust in formulating, the post-World War II regime and thinking about the role of the UN Declaration for Human Rights, the Universal Declaration for Human Rights, and also the Declaration, the UN Charter, I can speak. And so let's start with the Charter, which was enacted 1945. It makes reference to fundamental human rights and the dignity and worth of all human people. And the 6 references to human rights within the Charter, though, don't really commit members to much beyond sort of promotion. So the UN Charter itself isn't a place where you see any sort of robust embrace of human rights, so to speak. But certainly following the Holocaust and the development of international criminal law, which I learned you all were talking about last week, and the idea that individuals could be held liable and prosecuted for international crimes, which had emerged somewhat after the Armenian genocide, but then certainly forcefully after the Holocaust. And that is clearly situating the individual on a plane to be regulated by international law, whereas before international law was mostly concerned with state responsibility. And like I said earlier, individuals didn't have claims that they could bring necessarily if they weren't represented by a state. It didn't have rights, so to speak. And so from this, it's not too far of a step to see individuals being ones that have rights, and ones that have rights just because they exist. And certainly you can think about the development of crimes against humanity and the like as sort of a place to look at that, and others have pointed to that. And when you look at the UDHR and you look at its text, some provisions of it clearly have in mind the final solution. You see the reference to torture, their right to life, non-discrimination, equality before the law. When you take sort of further reflection, some have argued that, this account, that human rights sort of comes out of the ashes of World War II, is sort of a disingenuous account. And Samuel Moyn is probably most infamous for this, but basically his argument is that, there is no Holocaust consciousness in the immediate post-war era. Human rights couldn't have been a response to it because human rights as a thing didn't really exist. Instead, there is an argument that human rights really doesn't come to have any real meaning until not just the immediate post-war World War II, but actually the anti-colonial movement is the place to situate human rights, because the idea of equal political rights for all really don't become popular until you think about nations becoming independent. India in 1947, Ghana in subsequently thereafter, and all of the declarations that are aimed at granting independence to colonial countries and peoples living underneath foreign occupation and the like. And if you think about the expansion of the list of human rights, as well as the groups of humans sort of are entitled to hold them, and that list not being limited to sort of a privileged few who are of a certain race, a certain gender, a certain sort of class, then human rights as having meaning in the anti-colonial space, because that's really sort of the first time you see a test and push for full and equal participation in public and private life, makes good sense. Moyn has argued that the UDHR completely ignored colonialism, and that much of the struggle against colonialism was about trying to achieve sovereignty, not necessarily about asserting rights internationally or even internally. And that the fact that sort of the anti-colonial moment doesn't really fit well into the historiography of human rights needs to be dealt with sort of as opposed to sort of just elided, because there is a tendency to be sort of overly celebratory in sort of thinking about the progress of human rights as this linear progress narrative. The anti-colonial story, Moyn argues and others, doesn't really fit neatly into that narrative and that framework. And so what does it mean that those fighting for independence were not invoking the phrase of human rights or appealing to the UDHR, even though decolonization was happening at the precise moment? In other words, did people regard the project of human rights as something that was emancipatory? Or was it seen as something that was superfluous? And how can that understanding of human rights help us understand the relevance of human rights today? And so the argument that Moyn puts forward is that human rights came on the scene when the anti-colonial train, so to speak, had already left the station. Gandhi's concepts of duties didn't really incorporate human rights. Many other prominent nationalist leaders, anti-colonial leaders, Nkrumah's declaration to the colonial peoples of the world of the Manchester Pan-African Congress included only the rights of all people to govern themselves, as Kwame Nkrumah being the leader from Ghana, the independence leader from Ghana. And so instead of the UN being this forum for sort of a new and emancipatory set of principles, the UN really actually appeared to be colluding in the attempted reimposition of colonial rule. Again, I mentioned the trusteeship system of the UN. The UN Charter mentions self-determination, but it only does so in sort of a rhetorical and subsidiary way. And the mention of human rights in the UDHR in the preamble was written by Jan Smuts, who was the former president of apartheid era South Africa. And so the UN, in some respects, is very much complicit with the colonial project, and human rights sort of as an emancipatory means of thinking about self-determination of collective peoples was not sort of the driver. And so soon, though, there comes to be a conflation of human rights and self-determination. And this is arguably, as Moyne puts it, not the progress of human rights, but rather sort of evidence of their entanglement with anti-colonialism and anti-racism. So those are sort of the main sort of historical points that human rights is often located. And so I wanted to think about post-colonial critique a bit more, because I think it helps us to expose, deconstruct, and greater understand the role of imperialism and imperialism as related to power, and the relationship between imperialism and colonization, and how the past of the imperial past may continue to be reflected in sort of neo-colonial guises. And one of the things that is important for unearthing is, to what extent, if human rights wasn't emancipatory at the time of decolonization, at the heyday of decolonization, is human rights still linked to imperialism? Is human rights still sort of linked to a sort of a universalizing project? In other words, if human rights is a child of sort of Western conquest, then can it be sort of salvaged from its colonial logic? And if human rights develop outside for any concern with the inequities of the colonial situation, or of without concern for the ravages of the economy, and the suffering of many people in the world that was racialized through systems like slavery, colonialism, and apartheid, then what does the rise of human rights as sort of a political discourse tell us about continuing inequality that exists in the world, continuing oppression and subordination that exists in the world, and continuing inequities that exist in relation to poverty, the climate crisis, and the like. And so what can we take away from all of this? And, depending on who you are and where you situate these different sort of flashpoints, how far we trace back the roots of human rights is meaningful, or perhaps it isn't meaningful. And one big question is, why does genealogy matter? On one breath, we could think of, okay, well, this poses problems because, you view the project through a particular lens if you only situate it in a particular historical moment. Also, there seems to be a struggle for, the meaning and significance and the soul of human rights. And that contestation is happening, funny enough, at the level of history, but not because it's sort of some history of a distant past, but because the history and the continuing vestiges of history continue to be felt today. And so I think the question of where do human rights come from is something that is important, because ideas don't come from anywhere. The past gives us a vocabulary, which in turn sort of shapes the ways that we think about problems and we think about solutions. And it's important to be able to understand at least what several foundations might be. And one of the questions is, okay, well, does it matter, right? So if there is an agreed upon foundation, then, can we still move forward with doing human rights work? And as I'm sure you've come into contact with and during this course, everything related to human rights is a subject of contestation. Even the notion that individuals should have rights was something that was controversial. And I don't necessarily want to say in the past, because I think that there are many places where there's ongoing discussion about whether certain individuals should have rights, and particularly We can see that in current attacks on LGBTQI and others, individuals in this country and most recently in Uganda. So that subject continues to be one that's contested. One of the critiques of sort of looking back at history is like, oh, we shouldn't put more weight on this. This is like problems of circularity. There are more important things than thinking about history. And one way of coming away from this all is, well, human rights ultimately rest on the decision to, human rights is a social construction. Let's just say and recognize it as a social construction. And it results from our action that such a thing exists through social action directed by these rights to make real a world that we envision. And so with that, you don't necessarily need to agree on what the foundation is because it's a social construction. So the argument goes, and that sort of falls in line with the overlapping consensus argument, which is that despite the lack of sort of foundational consensus, meaning we don't agree on the origin story, but we've accepted normatively that human rights as an enterprise is something that exists, that we think can help us and that we think can help us shape the world. And so human rights as an enterprise is intrinsically complex, multifaceted. It's not really useful to think about some single origin story. But I think even in that takeaway, I think it's important for us to be clear on what we mean when we speak about human rights, right? So human rights can mean very different things. It can be an idea, which is, and if we're talking about human rights as an idea, then we're focused on sort of vocabularies and elaborated discourse about ideas. But that doesn't necessarily require institutional manifestation. If it's just about human rights as a concept, human rights can be considered a social movement. And there are many different social movements. And so we would need some clarity on why its specification as a social movement is something that's important. Human rights can be regarded as sort of a practice or institution. Human rights as a legal regime, which is, I think, I'm situated in law school, I teach law, and that's primarily the level at which a number of actors, I think, engage in human rights, right? It's a legal regime. We focus on the institutional manifestations of it as a legal regime at the national or international level, regional level. Human rights as a system has been argued to, help to promote the respects for rights of individuals and groups around the world. And so one of the things that I think it's important to take away from the story that I was just telling you all is wherever you seek to locate human rights, I think we have to, given where we sit in this present moment in time, trouble any sort of linear progress narrative that is generally celebratory and triumphalist. Because the history of human rights is long and deep, progress has not been linear or even predictable. I think that sitting here post-Roe, things that you think are sort of settled can quickly become unsettled in terms of recognition of your autonomy over your body and your ability to have rights to healthcare and the like. So linear claims are suspect. The Human Rights Project is not sort of always expanding forward in a way that is necessarily more inclusive. The Human Rights Project also leads to contestation of counter claims, where others then formulate their claims as rights. And so it's important for us to think about the role of rights rhetoric and how discourse around human rights may not necessarily be the most emancipatory, lead to the most emancipatory end. And if we are so focused on sort of drawing a clear line in history, then we might exaggerate continuities or exaggerate discontinuities. And either one is going to be a problematic thing. And a chronological beginning doesn't really make sense because of the existence of so many highly plausible competing theories, like I have just articulated. But I think one thing we can be sure of is this, always progressive from ancient times to the present, universality evolved throughout history, where we just leap from one historical moment to another without any sort of causal lines or lines of transmission, or even sort of account for political economy, or account for the role of imperialism and the like. Risk that what is human rights becomes just sort of what the history of certain countries are. And there's also a challenge with incorporating all historical struggles for concrete rights. So even as I started thinking about the Haitian Revolution, thinking about the 1920 Declaration, there's also a challenge with incorporating all historical struggles for concrete rights and privileges, which were not intended to be universal, and were strictly tied to specific groups, and sort of decontextualizing that as sort of for all humans. And that, I think, is something that is particularly important. But one of the things that is clear is that human rights as a radical tool, and is a radical tool, certainly for those who've never had them, and that it's, as Mikhail Matua has said, it's preferable to have human rights than no rights at all. And so I think where we can leave off with the hierarchies and histories of human rights is that it's important to center excluded subjects, excluded zones, as Matua has advised us, excluded histories, to sort of bring the project of human rights to greater meaning, and to allow it to fulfill whatever potential it's going to do in this world. So I'll stop sharing my screen and look forward to your questions. I didn't cold call on anybody.
I'm the least important person you need to see at this moment, so we're going to try and figure out how to see them. But then what I'll do, just to facilitate, is call on them to ask a question, and then see if you can hear them. We'll just let the conversation flow from that, and if not, I'll repeat the question and we'll let it flow from that. Okay. So who wants the first question? Well, let me put it this way: who wants the second question?
Either way.
All right. Listen.
Yeah, sure. So can you hear me? Okay.
Yes.
Okay. So you kind of ended your talk talking about like it's important to center like excluded subjects, excluded zones. And I feel like we kind of like touched on this with the declaration that you talked about from the 1920s earlier. Are there any other like types of histories that you think are like across the board excluded that you would want to talk about or wish more people talked about?
Oh man, yeah, there was a whole other class. No, yeah, I think that there are many ways in which the story of human rights can be told as a history that is, for example, one which focuses preordinately on the role of men, for example. So I think there are ways in which gender gets obscured in the conventional human rights story. And the work that feminists have done to unearth the ways in which that there is a need not just for sort of a formal allocation of rights, meaning sort of addressing underrepresentation of women in political positions, but that there is a societal lack of recognition of the rights of women at all levels, and that there is a need for thinking about equality beyond sort of a formal approach, but for one that is focused more on substance. And so anywhere where the story of human rights doesn't focus on how human rights as a project has further subordination, in the sense that to the extent that only the rights of men were recognized for a very long time, the critique is that human rights don't adequately address women's concerns, even just the way in which so many things are formulated around public harms. The critique is that, human rights are gendered, they're male-oriented. Rights have been defined by men and tend to regulate the public sphere. And so that means that the interests and concerns of women, which might be typically associated with the private sphere, get disregarded. And so that allows for continued subordination of women in ways that are very problematic. I think the biggest, I don't want to say biggest, but one of the main ways that human rights genealogy sort of operates is to obscure the role of the market and to obscure the role of the private sector. And so human rights as methodology can be used in ways to reinforce the status quo and not question other structures that are causing subordination. And so we have individual claims that we bring against, a state actor, and it's the state that is responsible for violations. And so the role of the private sector in the main can be obscured because there's a tendency to sort of channel our disputes into sort of very narrow, very legalistic disputes, which don't sort of get at larger structures and larger ways in which the logics and sort of functioning of the field of human rights tends to cast our attention away from the role of the market and its ravaging effect. And so to the extent that human rights law draws our attention to immediate harms, right? The immediate human right violation, we're not going sort of upstream, so to speak. We're focused on individual suffering and dispossession. Not that that focus is a bad thing, but there is a way in which the focus on the particular individual and individualizing the problem, let me put it that way, obscures structural and root causes of phenomena and can lead to scattered responses. This claim before this court, that other claim before some other court. All of the things are sort of individualized, and there's not really sort of a systemic approach at dealing with a problem that is systemic. And so it's not to the extent that the practice can lead us to focus on sort of worst case scenarios as opposed to systemic issues, then that is a serious downside to human rights. And I'm sure you all have probably read the downside of human rights or have referenced it before. But yeah, that's a huge concern. Thank you for that question.
Thank you. Could I just jump in and take you back to 1920 for a minute also, since this question sort of started there. We were just in the OAS. I took 8 students there, and I hadn't known that they had renamed their front hallway after Marcus Garvey. I don't know if you've been there recently. I wasn't aware of that. It was noteworthy, and I wanted to just take you back to that moment and think about Garvey himself. A figure who was relentlessly pursued by criminal prosecutions, who was deported, I think, and threatened with deportation. And yet that may have been the one moment when these two apparently contradictory aspects of the human rights movement, self-determination of peoples and a universalist aspiration to rights, was actually brought together in this one document. And I just wanted to pause on that, maybe invite you to speak a little bit more about it, because it does strike me as an extraordinary fact and really an important answer to Moyne and that particular critical strand of scholarship that argues that human rights really began in the 70s, which I personally do not agree with, and I suspect you don't either.
Yeah, no, the idea that human rights just sort of comes out of nowhere, and that it was never used as sort of an emancipatory tool by groups struggling for their greater rights and the like, is not something that is sort of borne out if we take any a closer look at history, and certainly not when you look at this particular declaration. And you raised an interesting point. Is it because of the way in which Garvey himself was maligned, as you mentioned, that the declaration has sort of also sort of gone in the waste bin? And even for those who are critical of the Garvey, larger Garvey project of sort of the Back to Africa movement and other things like that, there's a way in which about the Back to Africa movement. You know Garvey, and about his work, and the claims around the fraudulent stuff relating to his dealings, and the like. But we're aware of that history, right? We're not, and so to the extent that we're aware of that history, we could also equally be aware of this history on this declaration and this large gathering that takes place at a time that is, there's so much that was happening during that time. This document is drafted in Harlem, and it's happening at a time where reportedly there are over 12,000 people who are in attendance. In August 1920, this is the first annual convention of the Universal Negro Improvement Association. Garvey had just founded it a couple of years earlier. During his inaugural address, he explains, the doctrines of the UNIA. And as we were just referencing, the organization would go on to establish a number of branches all throughout the world. What happened at that particular convention with respect to this declaration, though, and its potential role in sort of understanding international human rights canon, gets completely elided. And so I mean, it's definitely something that I want to return to and dig deeper and do more research on and writing on, because I think that there is a way in which this and others are response to sort of human rights just coming into being after 1970 or something like that. And so I thank you for the invitation to be able to reflect more on sort of the significance of the moment, and the Constitution writing and drafting that they were doing, and they were doing so specifically for Black people, but not Black people sort of just located in Harlem or just located in the U.S. This was a sort of a Pan-Africanist vision, or a diasporic vision, or one that related to Black people all over the world. And so that is something that, whether situated in the US or the Caribbean or across the African continent, that is something that I think is particularly important, because that's certainly not universal, but it's more universal than some other projects, right? That we talk about as, an important source of thinking about human rights. And so to the extent that this project, which is thinking about people across several continents and the rights of people across several continents, I mean, why do we not have further excavation of that just sort of as a standard, as a standard thing for understanding the development of human rights and the role of human rights,
It's 3 years after the Bolshevik Revolution. It's the beginning of international socialism. It's 1 year after the Palmer raids. It's concomitant with the rise of the FBI and J. Edgar Hoover. I mean, there's so much going on just in that moment. It is a very fertile moment in U.S. and global history. Let me turn it over to our second interlocutor, Emily.
Something I was thinking about when I was listening to you talk was how if we could expect anything to kind of shake up the dominant Western centric individualist kind of narrative around human rights, it would maybe be maybe a shift more towards social and collective rights, such as those kind of articulated in the 1920 Declaration and kind of other non-Western critiques of the dominant narrative. It would have been the COVID-19 pandemic, where the kind of fates of individuals were just inextricably linked to each other. But from what I could tell from the outside, as someone who's not super immersed in the field, it didn't seem like the pandemic really shook up anyone's conception of human rights. And I guess I was just wondering if you could kind of speak to that a little bit, and whether you're aware of kind of like, I don't know, any sorts of shifts, both in like how we think about rights and our institutions as a result of the pandemic. And like maybe thinking ahead to other kind of communal crises like global warming and things like that.
No, thank you. Thank you for an invitation for me to talk about global health, which is, which I always love to do. But so to your question, I think that there is a way in which the call of your question, when the beginning of COVID started, I think many were sort of optimistic, right? That this would be the great uniter. COVID was going to bring us all together to fight this common foe, and that we would see solidarity, we would see all these other things, and we would, to the extent that, again, the great leveler, this particular novel virus, which we hadn't had any exposure to before, we were all susceptible as humans. You would think that this would be a space to, and it wasn't about sort of, with past pandemics like HIV and AIDS, where there was an attempt to limit the category of who's vulnerable to those who or engage in risky behaviors. This wasn't about sort of changing your behavior to the extent that folks have framed HIV and AIDS about, particularized groups, and that's really only the concern. This is something that's airborne, right? And so if you breathe, then you're at risk of getting COVID. And so, how do you limit that risky behavior? And so COVID was supposed to be an entry point for thinking about the relationship between human rights and global health. And what we saw was that both human rights, I think, and global health took a background to sort of like more securitized approaches to dealing with the pandemic. And there was not, there certainly wasn't solidarity, but there wasn't an attempt to sort of think about the role of equality, right? So this is supposed to be something that we are all equally susceptible to. Obviously some are more vulnerable than others, older people, those who work in high-risk environments, in healthcare environments, and more public-facing positions and other things like that face more exposure. But so much of what the pandemic has revealed is so much of how we continue to grapple with problems of substantive equality, even in the space of, and even in the face of a pandemic. And we've not really sort of gotten out of that. I guess part of why I'm struggling to answer your question is because I want to have something that's hopeful, but I don't actually, because I think that what has happened is that there's a declaration, there is a sense that COVID is over. There's a sense that, we can sort of all move on or what have you. But that determination is based on a decision that it's okay for X amount of people to die, weekly, daily, monthly, and it's okay for X amount of people to have long COVID. And there is a way in which people are rendered disposable that fall on historical lines of subordination that I don't think we've sufficiently used this sort of human rights project to bring claims to challenge governments, to challenge international through sort of either international fora, regional fora, and the like, for their policies that have made a lot of adverse consequences in terms of likelihood of exposure, likelihood of, all of our life expectancy in the US is reduced as a result of governmental policy. Like, that's what COVID has done. And the functioning at the international level has just even widened the gap between those living in the pandemic in the global South and those living in the global North. And we can think about this on so many lines: access to medicines, access to tests, access to therapeutics. So not just vaccines, but also thinking about treatment. All of this has sort of been exacerbated in sort of inequitable ways. And the mechanisms for human rights, I don't think, have been fully responsive. I mean, certainly global health mechanisms haven't been fully responsive either. I think one of the projects that I'm involved in is sort of articulating what human rights requires in times of a public health emergency. Me and other experts have been working on sort of what are the basic principles for human rights that you have to abide by in a public health emergency. And I think we've drafted, we've redrafted, keep drafting, and are still revising, and we haven't released it yet, in part because I think that there is disagreement on a number of key things, but also because as the pandemic continues to evolve, the nature of the human rights challenges continues to evolve too. And so I think this is the pandemic and the climate crisis are one of the biggest challenges for our world. And I think also for human rights, because if human rights isn't going to be isn't sort of helpful for thinking about addressing a pandemic, addressing climate change, if the rhetoric of human rights, the language of human rights, thinking about sort of articulating claims based on the right to health or the right to a healthy environment are not going to get you to where you need to be in terms of climate mitigation and a reduction of emissions, that's a big problem, right? So if we're not able to use human rights as a tool to address the biggest challenges of our lifetime, of all of our lifetimes, then we really have to question what the project of human rights is for. And I don't have an answer here because I think we are all still muddling and grappling our way through how to best use human rights. I think that one thing that we have been able to do is sort of push the baseline through different challenges, legal and otherwise, impact litigation and the like. But it is a push, and it is a constant push, and it's an uphill battle. And the urgency of the current moment, it doesn't feel like we're meeting the urgency of the current moment at all. So sorry, I'm sorry that I can't offer more positivity there, but it is something that deeply concerns me, and it is something that we have to figure out. We really don't have a choice.
I might weigh in and make your pessimistic answer even worse by pointing out that to the extent that the virus itself, as you say, was a universalizing threat, the response has been the exact opposite. What we've seen is a reaffirmation of state sovereignty, government power. It's sort of the exact opposite of what you might have thought, that it could have been a global democratizing thing. I fear we're seeing the same thing with climate change. It's just people are retreating into their borders and their camps. And that's the exact opposite of what the human rights movement was supposed to be about. So we definitely have real challenges here. We have time for one more question, I think, and then I'm about to offer you a fancy dinner whenever you come to Boston. But just say it again.
Thank you for speaking to us, Professor Sirleaf. I wanted to ask, in the context of the reading we got, Savages, Victims, and Saviors, on sort of the deeply Eurocentric and Westernizing missionary-like focus of human rights groups and human rights law, how we should approach the global struggle for LGBT equality today. When President Obama spoke out in favor of gay rights in his second term in his trip to Africa, he was booed by several African leaders and told that while he was welcome as the first Black president, he was not welcome to promote America's sinful values where they don't belong. And it's an area where, in spite of the progress made in some countries, it is largely a dividing line between what are typically called Western countries and non-Western countries in terms of legal protections for LGBT rights. So how can we advocate for LGBT rights and support LGBT people in the US where they need support too, as well as abroad, without sort of trying to project colonial mentality?
Oh, thank you for that question. Thank you for the provocation. I mean, I think that part of what we have to do actually, and it's great to sort of understand, sort of circle back to this question of history. But if we think about the role of colonialism in furthering not just, there was a bunch of different things, but there were certainly an impact of colonialism was thinking about very narrow views around sexuality, very narrow views around what is acceptable in terms of sexuality, and which got grafted onto perhaps different ways of being in terms of sexual orientation that existed in pre-colonial spaces in a number of places on the African continent. So I don't think it's accurate to say that there is this sort of huge disconnect, because I think if we look back to a number of different places in Europe and otherwise, you can see how there is a turn to thinking about sexual orientation in sort of really restrictive and repressive ways that dovetails not completely, but a lot with the colonial project. So I don't think that we should miss that point. The other point that I think is important too is to think about the role of US funding, certainly for different religious organizations and the like, has been material in a lot of the success, quote unquote, and success is definitely not the word to use, but in terms of the laws that have been passed, which are penalizing individuals for engaging in quote unquote, deviant acts or whatever the language is. I'm forgetting the language of the particular bill that just passed in Uganda and was recently being celebrated in problematic ways. But the role of US organizations in terms of was so fundamental in that. And I think part of what gets lost is those organizations in terms of funding, in terms of pushing particular agendas around understanding, what marriage is supposed to mean, what sexual relationships are supposed to mean, and so on and so forth, is being advanced by a movement that is well financed. And so it is not, those things are not disconnected. Like what we see happening here in the US with the restriction of the space, particularly for trans people to just exist, and the hectic restriction of the space that we're witnessing in places like Uganda and elsewhere are not unconnected movements. And so I think it's important to understand the transnational dynamics that are at play, because I think that the challenge for LGBTI and allies is in recognizing that the struggle is one that has to be a multifaceted one. It's not just sort of an individual sort of state by state or city by city thing. It's about challenging the source of support, the funding streams and the what have you. And certainly if we think about the lobby interest of actors that are really active in this space, and counteracting that at a domestic level, counteracting that at an international level, is something that has to be done. And so I don't think I hear you in terms of like, how do you engage in advocacy without sort of reinforcing this savage savior metaphor. But I think the way that you do that is by understanding the ways in which organizing around repression in this space is not at all disconnected, and recognizing that being able to make advances for rights in this space, that the movement and organization has to be one that is transnational, and that the challenges, though they may seem different, are actually very much related. And so the backtracking, the very hectic backtracking that we are seeing in this country is not unrelated to what we are seeing happening in some places that you're referencing. And so I think we have to be mindful of that and think about advocacy, recognizing that reality. Yeah, but thank you for that invitation.
Thank you. That's an excellent note to end on, to remind us that rights arise out of political struggle and solidarity and human movements. So that's a way forward to think about. I want to reiterate my immense gratitude to you for taking your time to do this. We really appreciate it. Were you here, we'd be offering to take you out to dinner, but put that in the bank. When you come to Boston, we owe you one, and I'll invite some students to join us. But thank you so much for your time. I really learned a lot. I really appreciate it.
Thank you guys so much. Thank you. It has been a pleasure.
I'll let you go now.
All right. Bye.